I'd like to welcome you. My name is Angela Tennis. I'm the Director of Insurance Services at PennPRIME Insurance Trust, and I have the honor and privilege of introducing both David MacMain and Brian Leinhauser from the MacMain Connell and Leinhauser attorney firm. Dave is the founding member and managing partner of MacMain. He has broad and extensive trial experience, having tried over 150 cases to verdict in favor of his clients. He has, over the course of his 30-plus year legal career, focused his practice on the representation and counseling of public entities, public officials, educational institutions, religious entities, and nonprofits throughout PA in a wide variety of civil rights and employment claims, including police conduct, zoning, land use, sexual harassment, discrimination, licensing, First Amendment, prison-based employment, and workplace claims. David is frequently retained as a consultant and/or lead trial counsel in high-profile Section 1983 and municipal liability cases throughout the country. He also serves as the solicitor for the Chester County Sheriff's Department and is counsel to law enforcement agencies and correctional facilities on various issues, including the review and preparation of policies and operational issues. Thank you, David. Brian is a founding partner of MacMain Connell and Leinhauser. He concentrates his practice in terms of labor and employment matters, school law, civil rights, business advising, and appellate cases. His employment law experience includes representing public and private entities as insurance defense counsel and privately retained in matters relating to labor relations, collective bargaining negotiations, personnel and human resources consultation, employment discrimination claims, internal investigation, and general litigation matters. Brian represents employers and individuals in defense of discrimination and harassment cases, administrative agency complaints filed with state and federal agencies, employment contract disputes, employee benefits liability, benefits litigation, heart and lung issues, wage payment collection act disputes, and FLSA collective actions. And at this point, I'd like to hand the presentation over to both David and Brian. Thank you.
Thank you. And thanks so much for having us on this evening. I understand this will be recorded and hopefully enjoyed and seen by a number of people in future viewing. Brian and I thank you very much for inviting us to speak. We think this is an important topic, and we kind of reversed the topic to A, make it a little more interesting, and B, Brian has 5 children that are soon to be, not soon, but they will need to go to college at some point. And so if you like employment suits and you like getting sued and you like meeting nice attorneys like Brian and I, then please follow these 10 lists of things and you're sure to enjoy an employment suit or two over your tenure in government. But in all seriousness, we based on the years that we've been practicing representing employers, both public and private, we've seen a number of things that you really need to avoid and not do in order not to get sued. Employment suits are extremely expensive, extremely unpleasant, both in terms of the time that's spent, but the drain on the employer or the supervisors of an employment facility. So without further ado, we're going to begin by giving you the top 10 things you should do if you like being sued for employment claims. So with that, Brian's going to hit the first thing.
There it goes. So first thing you want to be looking on the lookout for is making sure that you don't adequately train your staff. If you are an entity that loves lawsuits in the employment arena, not taking the time to train your supervisors is an issue that we come across often. And this falls into a few categories. One is just changes in the law, not updating your staff on what changes in the law have come up, and we'll talk about a few later in this presentation, is one of the ways that employers get into trouble in litigation. And another one is not training your supervisory staff, especially how to intervene when employee disputes arise. The methods for intervening in these issues or in training your supervisors on changes in the law vary, but our recommendation often is to get your staff together on a regular basis, whether that's at your staff meetings or even at your annual trainings for your staff, to make sure you have somebody come in and just give an update, what the current state of the law is, even in the last year, definitions of various items under the law have changed, and it's important that you make sure that your staff gets adequately trained in those areas. So it's always a good idea to have a skilled employment lawyer come in and give those training because they can have it ready, give it to you, take an hour of your time on an annual basis and get those things into your staff's head so they know what they're supposed to be doing. The second thing that we run across often is employers running afoul of Title VII and the Pennsylvania Human Relations Act in terms of discriminating against their employees or discrimination under the the Age Discrimination and Employment Act, the ADEA. Title VII and PHRA discrimination falls into two basic categories. One is, adverse employment actions that discriminate. Those things could be in hiring decisions. So utilizing someone's protected class status, race, color, national origin, sex is in the statute, and we'll talk about that definition in a minute, and religion. If you're discriminating in hiring decisions based on any of those factors, you can face employment litigation. So it's important to have an evaluation of your hiring practices that way. Similarly with termination decisions, suspending an employee or enforcement of employee workplace rules or promotions and raises. Any of these things that you do on a weekly, monthly, annual basis with employees that have a basis or a perceived basis in any of the protected class status can give rise to employment litigation or discrimination. So it's important for employers to know and have their policies evaluated in a way that protects them from that. Discrimination in these areas can take a lot of different forms. It can be offhand comments. It could be specific use of words. It could just be, the impression that an employee has of your hiring practices. And so avoidance of that can also include things like we said, to educate your supervisors. It's also a good idea to keep your employees educated about your process and how you go about doing things. The Age Discrimination Act is discrimination of individuals over the age of 40. 40 seems a little low to me now that I am above that age. But protected class and protect from discrimination on the basis of age in those same categories. The Age Discrimination Act is a little different than the others because if you are alleged to discriminate against somebody on the basis of age, that has to be the only basis for the discrimination. It can't be I was a bad employee and they thought I was too old to do the job. If they have another legitimate business reason for terminating you, then the age discrimination claim is much harder to prove. Unfortunately, the cost of going forward in litigation under an age discrimination suit is still the same. And so avoiding this as one of the ways to avoid litigation would be a good idea. Discrimination in the past has been a little different. The definition gets broader every year. In the past, it was mostly supervisors making inappropriate comments or inappropriate advances to younger employees or female employees. Now, there are so many other things in the world that we're dealing with that reflect possible discrimination that you have to really be up to date on what you're utilizing as far as your vernacular, the words you use every day. So phrases like off the reservation, 10 years ago, no one thought for a minute that might be offensive in some way. But when you look at the origin of it, and if you have a Native American employee that's working for you, they might be offended by that. Locker room talk, especially among municipal officers and things like that, can be something that puts you in a position where you are giving rise to litigation. Words like uppity or old man, hey, old man, he's a golden ager. That can be perceived as age discrimination as opposed to really just a compliment to somebody for their years of experience. So you have to be careful on that front.
Right, if I could jump in real quick. So I think that, one of the comments we get when we do this live and we have hands raised and questions is, you know, you have to weigh everything you say these days, and you have to be extra careful. And I didn't mean it that way when I said it. And the fact of the matter is, I think we all need to be more sensitive to phrases that we just have used. And Brian gave the example of off the reservation. There was an incident recently with a college basketball coach who had had several losses, and he was trying to kind of keep the team together. And in a locker room of basketball players, he said, everybody stay on the plantation, or something along those lines. Extremely offensive comment. He was insensitive in the way he said it. I think there's certain things, that phrases that we may just have grown up hearing in an earlier era, that are unacceptable. And I think we have to be more mindful. One of the first employment litigation cases I had to do with a male supervisor patting a secretary on the backside occasionally. And when I met with the client, it was like, that's just so-and-so. He's older. He's been doing that for years. That's just the way he is. He didn't mean anything by it. Well, unacceptable, completely unacceptable. And so I think we have to be much more conscious of words can impact people. Phrases that we may have thought were funny may not be so funny to certain people. And so I think we have to be much more sensitive as to how we treat people. And I kind of think one of the phrases, kind of the golden rule, is this something you would say in front of your grandmother? Is this something you'd want someone to say to your wife in an employment setting? Is this something you'd want your son or daughter to be exposed to? And so the defense of that's just the way it always has been, or I didn't mean anything by it, there's no such defense. If it's offensive, if it's discriminatory, if it's uncalled for, it can be actionable.
And the other thing about this particular issue is that the norms of society, what was once acceptable isn't, and it's important to keep up to date on that, harkening back to, training your staff, training your supervisors. As far as defenses go to a claim in this arena, having a legitimate non-discriminatory reason for disciplining or terminating an employee is important. It serves as a defense discrimination claims, but you have to make sure you're documenting that well, and you have to make sure that you are not only able to articulate the reason for either the discipline, the non-hire, or the termination, but also that you have documentation of it. As a rule, I always like employers to have a conversation with an employee if they've gotten to the point of termination. That conversation should never be a surprise to an employee. They should have known that their performance was deficient. They should have known that they were not following the rules. If the first time you call an employee into the office is to tell them, hey, today's your last day, or we're letting you go, then you haven't done your due diligence in terms of coaching that employee and helping them understand what your expectations are. And that's where you end up with a recipe for litigation, as opposed to building the information and gathering the information all along as a habit on a day-to-day basis. Not every discipline of an employee needs to be a write-up, but you do need to make sure that you have the ability to understand what's going on and explain to an employee, this is my expectation, this is how you're not meeting it, because that's how you'll have the documentation needed to establish this non-discriminatory reason for termination.
Number 3, if you enjoy employment suits, don't give reasonable accommodations to your employees that need them. The Americans with Disabilities Act of 1990 has been in place for quite a long time. It prohibits discrimination in the workplace against persons with recognized disabilities. And in simple terms, you need to make reasonable accommodations. Now, what's reasonable? What's a reasonable accommodation? It's going to depend on the situation. If it permits an accommodation permits an otherwise qualified individual with the opportunity to perform the essential functions, which importantly doesn't create a hardship for the employer. There is kind of reasonableness is a term that kind of goes both ways. It may include permitting use of accrued paid leave, provided additional unpaid leave for necessary treatment, light duty, work from home, It's been an issue, frankly, over the past year that, well, it may not be an ADA issue. We've all had to make reasonable accommodations with employees to the current COVID pandemic. We had to be more flexible, allow people to maybe work remotely more often, to have distancing and the various other things. And so it's all part of the interactive process. We need to try to work with employees to try to keep valuable employees that may need some accommodations. What's important, and Brian touched on it on the last slide, is not only working with your employees, but documenting what efforts were made, documenting the outcomes, having clear job descriptions going in as to what outlines essential functions and what is necessary for this particular job. We have a matter right now where there's one of these type of claims. The employee needed to be able to go out to evening meetings, needed to go out and interact with community groups. And because of some of the issues she was having, she was unable to do so. And the employer, to their credit, and with the advice of Labor Council, worked and tried to make reasonable accommodations over a period of time. But one of the essential functions is the employee had to go out for evening meetings and meet with people. And because of vision issues, this person was unable to drive at night, was unable to go to certain meetings. And it got to the point where through the interactive process, they just simply couldn't perform some of the essential functions. Doesn't mean we still don't have a lawsuit, but to me, it's much more defensible because the process was followed, efforts were made. The employee was more than reasonable in trying to work with the employee.
And that, so let's assume you've followed the first three rules. You haven't trained your staff, you've discriminated against them under Title VII, or you refused somebody a reasonable accommodation. Where are you going to end up? You're going to end up at the EEOC if you're a private employer, and the PHRC if you're the Commonwealth. And that's the first stop on a discrimination claim. And this is where employee goes to file their claim and say, my employer is not treating me appropriately. Either I was disciplined, I was fired, they didn't treat me right. And an employee has 180 days or 300 days, it's really 300, to file their claim with this entity, which is a long time. If you think about it, it's almost a year. Something could have happened as recent as far back as June of last year, late June of last year. And an employee could go to the PHRC and file a claim today against you. And we're in April. That's a pretty long time for somebody to wait and deal with an issue. If you get a claim like this, you should contact your counsel right away. There's things you're going to need to do, response timelines that are critical. Do not go it alone at a PHRC EEOC hearing. Don't file your response letter by yourself. There are issues and information that should be in every one of those responses that you need to have. And if you don't have them, you might not be able to raise them later. The other thing about these claims is you have to make sure that under any of these statutes, you don't retaliate against your employee. Retaliation claims account for a very large percentage of the ongoing litigation under the discrimination statutes. And retaliation is interesting because an employee could come to HR and complain about something. We had a case, resolved it, but we had a case where a guy went to HR and complained, I'm not getting a raise. It's not fair. I haven't had a raise in 3 years. The employer had documented well the employee's deficiencies in performance. The employer had maintained all the appropriate references regarding their inability to do a better job and the reasons they didn't give them a raise. And when they didn't get a raise after they went to HR, they filed a PHRC complaint. Said, I think they're not giving me a raise because I'm over 40. And he was 45. And there were plenty of employees in the workplace that were older than him that were also not getting a raise because nobody was getting a raise. The company had fallen on hard times and they weren't getting the revenue they needed, so they froze everyone's pay. Well, the employer received the complaint from the PHRC, called the employee into the office and said, did you just file this against me about this raise issue? He said, yeah. The employer said, well, you're fired. So that's a retaliation claim. His claim for not getting a raise had no merit whatsoever. Zero merit at all. But the retaliation claim was clear and actionable on its own. So that employee had a recovery against that client. They called us after all this happened, just so you know. But he had a recovery against that employer because the retaliation claim could not be clearer. He complained about a harassment issue. He thought it was related to his age. He complained to the PHRC and got fired for it. So please be careful that if an employee complains about a harassment issue, a discrimination issue in your workplace, if you want to meet us and have us represent you and help put my kids through college, by all means retaliate against an employee, because that litigation takes even longer and it's a very hard road to hoe. For the next one, I think, David, you're up next.
So if you enjoy employment claims, don't evaluate your employees. Don't let them know how they're doing. Don't let them know if they're following policies, whether their performance is deficient. You need to make sure that you're evaluating your policies on an ongoing basis. And this, I guess I jumped ahead, Brian, to the fifth slide instead of the fourth one. So, but you need to evaluate your policies to make sure they're not discriminatory in any way based on a protected class. There's a civil service process. Have your policy manuals reviewed regularly. What I advise, and I do a lot of work with police departments and police policies, as well as prisons, I advise once a year, do an annual audit of your policies. Look at your employment manual, go through them, look to see if there's something that maybe has changed going back to the first slide based on the past year changes to the law, and just give it a fresh review every year. Have, someone look at it and make sure it's appropriate. And then in addition to that, if there's a change in any of your policies, notify in writing your employees of the change in policy and document it. Put memorialization of it in their personnel files that it's been sent, they've accepted it, they understand it, and you're evaluating things.
And there's a lot of electronic platforms and a lot of things you can do with your electronic communications for your employees that will help you document these things. Blast email to all your staff, blind copy saying, hey, this is a new policy we're implementing, is a great way to get the message out there. And then a return receipt or an auto open receipt for each employee that you can print out and put in their file or download and save to their electronic employee file is a great way to track what they've opened, what they haven't, so that you know who to follow up with on those things. But looking at your employee manual on an annual basis or more often is an important way to make sure that you avoid meeting us and getting into litigation.
I already talked about some of this. I apologize, a little preview of what was ahead, but it's important you have some form of an evaluation process. It doesn't have to be exhaustive. It doesn't have to be overly overdone, but there needs to be some form of an evaluation process. Are you going to have a probationary period for employees? If so, communicate clearly what that is and what's expected and what markers they need to meet in order to make it beyond the probationary period. Give feedback, particularly with newer employees. Are you going to do an evaluation yearly, or are you going to do one more frequently than that? Is the evaluation going to be in writing, or is it going to be an oral, sit down, talk about what you're doing well, what you're not doing well, areas of improvement? Are you going to ask employees to self-evaluate? I've seen some law firms I've been involved in where employees or lawyers have been asked to kind of do a self-evaluation of how they think they're doing, areas that they're strong in, areas they need work in. I think the self-evaluations serve a purpose, but it's something you need to consider when you're doing an evaluation process. And then finally, if you have an employee who's deficient in some way, we're big believers in a performance improvement plan where you sit down and in writing, you spell out, here are the things you're struggling with, or here are the things that you're deficient in. And let's talk tangibly about the things that are going to help you improve upon your performance. And you kind of come up with an action plan. You set a time and you sit down with the employee at the end of that, say 30 days, and see if it's met. And you document it. And that allows actually Brian and I, if we're going to defend you if there's a later suit, to show that there has been an effort to try to correct and remedy the problem, work with the employee. There's tangible markers and goals set and what's been done to help the employee improve. Best case scenario, the employee understands and is clearly communicated to as to what's deficient. Their performance improved. You've helped the employee do a better job and meet expectations, and everybody's happy. Hiring, training new employees is incredibly time consuming and expensive, and you want to make sure you're giving your employees the tools to succeed. And if you're not, or if there's a problem, having this evaluative process, whatever form you choose, is important.
And on this evaluation, this shouldn't prevent you from giving feedback to your employees on a regular basis, but you really should have some kind of process in place regularly where you're giving direct feedback, where you force yourself to give feedback to employees on a regular basis. That way you're not, I know with a lot of public employers, when they have a union and the contract dictates what their raise is going to be, and they're like, oh, well, it's easy. I don't have to sit down and tell them they're doing a good job. They're going to get the same raise no matter what. But if you force yourself and you put yourself in a policy where you're going to sit down with an employee every year, every 6 months, whatever it is, it helps you to establish, you reflect on their performance and establish what your expectations are to see if they're actually getting the job done.
This rolls into the next slide. One of the things that you need to be is honest. If an employee is deficient, if there's areas of needed improvement, you need to communicate that. And that can be difficult, particularly with folks that are supervisors for the first time. And now they have to say, look, you need work in these areas. It's hard to be honest sometimes. But if everybody is exceeds expectations across the board, you're not doing a service to your employees, nor are you put yourself in a good position if you need to discipline or relieve an employee of their responsibilities. Because if we look at their evaluations that have been done, everything's a 5-star across the board. And now you're telling us, well, they weren't a very good employee and it's been a long time coming. Well, if the paper trail doesn't reflect that, it's kind of hard to explain it away or come up with a different explanation as to why an employee was let go. And it leads them to think, well, there must be some other reason other than performance, because my gosh, the last 5 years, I've got nothing but 5s on all my evaluations. The other thing, and this is important, is have some kind of objective criteria for how you measure employee performance. Finally, and we talked about this previously, have some kind of metric for improvement and a concrete improvement goal, if possible, if you have deficiencies. But the evaluation process is critical. It helps you as the employer. It helps the employees know what they're doing well and what they're not doing well. And at the end of the day, it's also going to protect you if there's litigation, if you've been honest in the evaluations. And as Brian mentioned earlier, if you're doing things right, an employee who is to be disciplined or terminated should not see it as an absolute coming out of left field. I had no idea. There should have been some conversation along the way as to deficiencies and areas of needed improvement.
And I'll reiterate just for everyone's benefit, be fair, be honest with people. Be honest about what your expectations are of an employee, because that's how you'll determine who is or is not exceeding them. Even your best employee has an area where they can get better. And so be honest with them about that and understand that, meeting expectations is not a bad thing. If you have a 4-point scale for your evaluation, needs improvement, satisfactory, exceeds expectations, outstanding, understand that people who get a bunch of 2s, satisfactory, you're doing what we expect, is not a bad rating. That's just an employee in a lot of areas that's doing exactly what you ask of them. And teaching and learning and giving feedback to your employees, say, yeah, you're doing exactly what we expect and we thank you. And reserving those 3s and 4s for the one area or a couple of areas where an employee actually goes beyond or far beyond what's expected is a good rule to follow. When we do get this litigation and when we have a client who has evaluations in place and everyone's getting 4s across the board or 5 stars across the board, the evaluation means nothing. But what it does is say, well, they were a 5-star employee all the way across the board, 5 years of evaluations where they were great. And then suddenly you fired them. There must be another reason. It's not that they were a bad employee. When you talk to that supervisor and they're like, oh, they were a problem all along. I just had to get that out of the way. Well, now you've created a problem for your defense because you can't establish that that employee was deficient. So that honesty is the best policy is really important in this area.
We are halfway through. I should have mentioned this in the beginning, but if anybody has any questions, you can send them to Angela and we will respond as we go along. The offer also stands if you have questions at some later point after the presentation, feel free to reach out to Brian or I. Our contact information is on the materials and the slides will be available for distribution for attendees. So if at any point there's a question as we go along for the second half, just fire away. So Brian, you're next.
Sure thing. So let's talk about public employees. Public employees can't be terminated without making sure that they've gotten notice, a hearing, an opportunity to be heard on whatever the allegations are. You know, public employees have a protected property interest in their employment. And so if they're appointed to their position, they have a right to get notice before you discipline or terminate them, have a hearing or be heard on that. And then, you know, that notice that you're sending them has to have things like what happened, what's the allegation, what information have you gathered? And so don't complete an investigation until you've had this meeting with an employee and bring this in writing with you. Here's your notice. Here's what we found out. Here's what we want to talk to you about. You know, this is for the serious termination cases. If you're having an everyday disciplinary event, hey, you're late, you should document that. Hey, you've been late 4 times in the last 10 days. Here's the sign-in sheets. I need you to know I'm going to save these and put them in your file. They don't need notice, opportunity to be heard, and an explanation of the evidence then. But when it rises to the level of termination, and let's say it's an employee attendance problem and they have a lot of Friday, Monday misses, and they're always late on the Mondays, they don't call out, you need to bring all that documentation that you've been gathering up over time with you and put it in front of them and say, this is what we have. Here's the pattern. Here's what we've looked at. Here's the times we talked to you before. Here we are again, and you're late, and here's the disruption it causes to our operations. Hear them out. You know, make sure that are unaware, you're not forgetting or missing something that you didn't know. What if that employee has had a health issue that you weren't aware of? You need to give that employee an opportunity to speak and say, is there anything we need to know about why this lateness issue that's reared its head over the last 6 months can't be resolved? And if that employee says to you in that meeting, well, look, you know, I have some new medication. I have a kidney problem that's been causing me grief. I have to take I can't work within 12 hours of taking my medication. I take it as soon as I get home every night and I can't be at work and it's causing me sleep issues and this and that. That employee in that hearing is now raising an ADA issue that you need to address. And so you need to have this conversation with an employee to make sure that there's nothing you're unaware of. And that's usually how I advise clients to ask that question. Is there anything we're not aware of that you want to share with us before we decide what discipline to impose? Because it gives the opportunity to that employee to say, well, this is my problem or that's my problem. Sometimes employees come to those meetings and say, look, I've been struggling with an alcohol addiction. Well, you might not have known it before, but now you do, and you have to do something about that. It doesn't excuse the latenesses in the past, but you have to react to that information before you decide what the discipline is. So be aware of that and make sure that if you have an employee that you're considering terminating, that you make sure you go through this process with them. It's a good practice. It's a great way to avoid having litigation come down the road. You have to make sure you have an appropriate technology use policy and a device usage policy. And you have to make sure your employees are aware that anything they do on an employer issued device, whether it's a phone, walkie-talkie, computer, whatever it might be, you should tell them up front, there's no expectation of privacy. This is our property, and what you do on it, we are allowed to look at. And that could be what you do on it at home, what you do on it in the workplace, during work hours, off work hours. If they're using your phone, your property, your computer, you need to make sure you have a policy that articulates what the expectation is. Because if you don't, your ability to discipline an employee for use of that device, off hours, at home, and things can be limited. You have to make sure that you have an up-to-date and robust social media policy. And when I say up-to-date, I mean the law is changing in this area on a pretty constant basis. The U.S. Supreme Court right now is weighing a case for an education case where the question is, if a student posts something on social media outside of school on her own device, but about something that came up at school, and it doesn't do anything to disrupt the school environment, can the school impose discipline? It's a school in Pennsylvania that is going to the Supreme Court with that question, and that case is going to impact every school across the country about what they can or can't do with regard to discipline of a student. And that's important information to have, but I think that case will signal what the Supreme Court would do if an employer-employee case came up with the same question. And so you need to be aware of those changes in the law, going back to issue number one, but you also need to make sure that you have a policy out there that's making sure that what you are allowed to restrict is restricted, what you're not allowed to restrict isn't. Now, for government employees, the rules are different. And so you need to be aware of that as well, and make sure that you are informing the employees of their restrictions, because government employees have different rights with regard to what they can and can't say in social media as opposed to others based on what the issue is. With regard to unionized employees, you should make sure that you, if you want to get sued or if you want to have a union appeal or an arbitration, make sure you don't provide those employees with the representation in their disciplinary hearings. Union employees have a right to have a union representative with them during a disciplinary hearing. And that definition is somewhat broad, and you need to make sure that you're aware of what their wine garden rights are. So you have to understand who's allowed to be a representative in those hearings, in those meetings. And you have to understand what the rights are with regard to taking a break. So let's look at wine garden just real quick. This case is from 1975, but it's still the law. Every union employee is entitled who believes that they are going to be subject to an investigatory interview can ask for a union representative to be with them. You don't have a duty to tell the employee they have a right to a union rep to be there, but if they ask you, you have to be honest with them. So if you're in a meeting with an employee and you're investigating an issue and they say, do I need a union rep with me or do I need somebody with me? You have to engage in that conversation with the employee. Do you think this is going to lead to discipline? Would you like to have someone with you? If they don't have a right to have an employee with them, if they're a witness and not a subject to the investigation, then they're not entitled to have someone with them. And so you have to inform them of that as well. So knowing who you're talking to in your investigation and what their rights are is very important. Messing this up can get you into a lot of issues related to how the discipline holds up down the road. So make sure that you are aware of who the employees are, what their union rights are, and whether or not they're allowed to be there. With regard to who they're allowed to ask for and the role of that representative, they're allowed to be there, the representative, they're allowed to give advice, they're not allowed to be combative, they're not allowed to interfere with the interview process. Public employees have an obligation to participate in the investigatory process, and they need to know that. But in exchange for that, they have to also understand that they have a right to a representative there, but that representative can't get in the way. The other thing is the person they ask for has to be reasonably available. If you're conducting an investigation today and they say, oh, well, I want, Bob to be my rep, and Bob's fly fishing in Canada for the next 2 weeks, you don't put the investigation on hold. You say, well, Bob's not available, please pick someone else. And if they refuse to pick someone else, you say, well, we're going to conduct the interview right now anyway. They don't have a right to stymie or impede your investigation by picking someone who's not available. If they can be here in an hour and a half, great, go sit in that room. When they get here, we'll start. But if it's, they're gone for the next 3 days, that's not an appropriate or reasonable ask, and they should find someone else. Number 9.
Number 9. So if you want an employment suit, just kind of ignore employee concerns, don't accept complaints, hope it just kind of blows over, and really don't address concerns as they come up. This is difficult because sometimes within a workplace, there's certain things that are amiss or awry, and if you ignore them, they're only going to get worse and fester. You address concerns immediately. You need to make sure you have a line of contact or communication outside the chain of command. So if they're uncomfortable going to their immediate supervisor, maybe that's the immediate supervisor is the source of the concern, that they have an avenue to go somewhere else to make the complaint or raise the concern. You often see this in sexual harassment complaints. If the supervisor is the one doing the harassing, your policy and your training has to allow them to go to someone else to make the complaint. Documentation becomes important. If there is a meeting about what the concern is, make sure you're documenting who was there, what was addressed, how it was decided. If you reach a resolution, here's what we propose to do to resolve the issue. Are you okay with that? Are you comfortable with that? Does that satisfy your concern? Document it. Make sure you have a paper trail. And then the final bullet point, I would hope would be understood, and we wouldn't have to discuss it, but we still see this in all kinds of cases. People put things in emails that you would be shocked. Maybe you wouldn't be shocked. Don't use an email communication to talk about sensitive things. Unless you're talking to your counsel, it's discoverable in litigation. And so don't use an email to either communicate things or say things that you'd be uncomfortable or be inappropriate for you to say to someone's face. I think sometimes there's a feeling there's some anonymity through emails or anonymity through social media or anonymity through communication that just doesn't exist. So if it's something sensitive, something important, something inappropriate, certainly don't document it and commit it to an email, because we will certainly see that email arise later. Big part of litigation these days is electronic discovery, where we're asked to produce any and all emails regarding such and such a topic between the following employees. It's an extremely expensive process, and it can be an extremely embarrassing process. So most importantly, address concerns, hit them head on, nip them in the bud, resolve the problem, and make sure that the resolution is acceptable. Well, it doesn't have to be completely acceptable, but you make a reasonable resolution and see if that satisfies people and you can move forward.
I'll give one of my favorite examples of this. We handled an employment litigation case a number of years ago. It was in the private sector, and the vice president of operations of a company sent an email to the human resources director that he thought was going to be really funny. And the content of the email was wildly inappropriate. He said, and I'm quoting it, "Please let me know when you'd like to schedule a weekly sex meeting with me. Would Friday at 10 work? And should anyone else be invited?" That was the text of the email that the director of operations sent to the human resources director who worked under him. Now, he thought that was funny and it was a joke, and they were friends and they had worked together for a long time. He had been to her house for a barbecue. He knew her fiance. That's a wildly inappropriate communication. And when the owner of the company called me and said, "What am I supposed to do with this?" And I said, "You mean after you fire him?" Because there's no recovery from an overt sexual harassing email like that to a subordinate employee. I don't care that he meant it as a joke. I don't care that he thought it would be funny. He was joking around. And the reality of that situation is, this is an employee who wrote something that was entirely inappropriate. The human resources director of all people, who knows what harassment looks like. And she went directly to the owner and said, "Hey, I got this email from this guy. I've been debating what to do about it." She sat on it for a little bit of time, not a long time, but because she knew they were friends, they had worked together, they had grown up together, they had been, helped build this company together over the years. Well, the reality is, he wrote something that was inappropriate. She knew, thank God, the avenue to go to, because she couldn't go to her superior employer, but people who write things and think that they're having fun with them or joking need to understand, and this goes back to the training aspect, need to understand that what they write and what they say can come back in another context and ruin their career. This guy was a vice president of a very successful company who had to face the disciplinary consequences of what he thought was funny, and in the end really wasn't. So, making sure your employees know what the expectations are important. And when you do get something that comes up like this, the investigation is key. You need to make sure that you are determining who the appropriate investigator is. You need to make sure that you define the scope of the investigation. So there are times when employers come to me and they're like, I started investigating this and I started pulling all these threads and all of these things came out of it. And I don't know what to do now. Can you come in and put the genie back in the bottle? Well, no, I can't. But what started as one investigation is now 3. And we'll get to the bottom of them all for you. But now you're in this process and you have to see it through to the end because you must complete the investigation when you start it. The worst thing you can do is start to look into something, not like where it's going, and then say, oh, you know what? Nothing to see here. We'll get back to it later, and ignore it. The investigator should prepare for the interview. Make sure that you know what you're trying to get at, who the person is you're interviewing, and what the end goal of that investigation is. You should not have less than 2 people in the room participating in the investigation. One person to be there and do the investigation, and somebody else there to take the notes. Otherwise, you end up in a situation where the employee who's reporting information to you says, that's not what I said. You should also circle back with those employees when you're done the interview process and say, I just want to make sure I got all the information right. This is what I wrote down. These are my notes. This is the information you shared with me, and I want to make sure it's accurate. In terms of picking an investigator, I prefer that you pick a lawyer to do that work because we do it all the time. But if you train your HR staff appropriately, they're skilled and they can do that work, but you need to make sure that they know how they're doing it and make sure they know when it's time to call somebody else in to do it. Investigations are key because they are what end up making or breaking a defense and a litigation down the road. When did you do it? How quickly after the event did you do it? And what did you do as a result of the investigation? All things that you need to be aware of and all things you need to be conscious of as you go forward through the employee process. Number 10, if you want to end up in employment litigation, make sure you do not follow the protocols or the established guidelines for discipline for employees. And this is important that you have all your policies written down, make sure that you're updating them regularly, but if you don't follow them evenly or distribute them or make sure that the employees know what the rules are and how to follow them, you're going to end up in litigation without a doubt. We have a lot of clients who call us. They say, well, that person has been with us for a lot of years, so we let that go. You can't do that. You can't, oh, that's just Bob. He's fine. That's just how he acts. That's not a way to discipline your employees because other employees will point at that and say, that employee got special treatment over me. And those are the things that really get you into trouble and get you into litigation. It's also important that you make sure that when you're updating your policy manual, that you're ensuring that the employees know what the process is. Make sure that the protocols you establish comply with the law. Make sure that you are knowledgeable and your team is knowledgeable about what progressive discipline looks like. Make sure that they know that there are no favorites and you're not allowed to give your friend a lighter discipline. Oh, I'm just going to give you a write-up, and then the other person gets a suspension on the other side. That's going to cause you trouble every time, and that's when you end up on our doorstep looking for help.
Bonus 11th thing. If you want to get sued and you've got a difficult employment issue, just go ahead and figure it out yourself and wing it and hope you got it right. Don't consult with anybody, your solicitor, your outside employment attorney. Just kind of do it on your own. And I say this tongue in cheek because, as Brian said before, most of the folks that are in HR doing this kind of work have a good sense. They're well trained. They know what they're doing, but you need to know when to go outside and get consult, especially termination, things of a more serious nature. I can say I'm now a solicitor myself, serving as a solicitor for our county sheriff. And there's issues that come up that are beyond my area of expertise and beyond my area of comfort. And when those issues come up, I bring somebody else in that's a specialist in that area. Your municipal solicitor may by trade be an excellent land use attorney, but employment may not be his or her forte. So make sure you get somebody who knows employment law. Make sure they're seeking advice from someone that knows what they're doing. And as Angela and Cindy can attest, through PennPRIME and the Municipal League, there's a number of really good attorneys that work for and with the pool. I'd like to think Brian and I are two of them, but we're in the eastern half of the state. There's some excellent employment attorneys that the league uses in central and northern Pennsylvania and the western part of the state. But please don't make any critical decisions on employment actions without seeking some guidance and some counsel in so doing. With that, unless Brian has another comment.
I'm just going to chime in. David started early on saying, I have 5 kids and I have college funds to fill. My favorite employers are the ones that call me after they've made a critical employment decision without talking to anybody about it, because I know that that's going to be a mess that requires a lot of cleanup work. We would really prefer, that employers give that call ahead of time. And, an ounce of prevention is worth a pound of cure is what my grandmother used to tell me. And inevitably, I find that to be true. You may get to the same end result after talking to an attorney, but they may give you a different road to get there. If you have an employee that is a problem and, you call your employment experience attorney ahead of time and they say, well, you have this and you have this, but it's not enough, then all right, well, then we're going to give this employee another chance. And if an employee is consistently a problem, giving them another chance is giving them another chance to be successful, hopefully. But if not, it's giving them another chance to demonstrate that they're not willing to conform to the rules of your workplace. And the more chances you give them to do that, the better off you are when you get to that final decision saying, all right, it's enough. Sometimes one action is enough, and consulting with a lawyer ahead of time gives you the protection. One of the practices when clients call me ahead of making a decision, I say, look, write down all the reasons you think you should terminate this employee right now and send it to me in an email. And then I'm going to call you and we're going to go through and talk them over. And that does 2 things to protect an employer. One, they can think about all the reasons they want to let somebody go, and writing them down is an act of intention. Hey, I want to know all the reasons. Number 2, if an employee says, well, you fired me for this other reason, when we get to a deposition, I say, hey, before you terminated this employee, did you consult with anyone? Yeah. Consult with counsel? Yeah. What did you do? I wrote down all the reasons at the time I thought I should fire this employee. Okay. Do you have that list? I do. I sent it to you, and here it is in my email, and here's the list. Now that email is privileged to me, but in a deposition, it's an invaluable tool to protect an employer against a discrimination claim, because I'll go through the list. You said this. Lateness was an issue. They didn't follow instructions. They were insubordinate. They used inappropriate language toward their coworkers because of their race or their national origin. And you ultimately decided to fire them for those reasons. Yes. And this is all of them? Yeah. Interesting, the age of this employee is not on the list. Or interesting, the race of this employee is not on this list. Well, that's because it didn't matter to me. Their conduct is what mattered to me, and that's what's on the list. It's a good step to take before you make a termination decision, because you may not avoid the litigation, but you'll avoid the liability because you've taken that extra step to talk to an attorney ahead of time. So with that, David.
Yes, with that, we're wrapped up. If anybody has questions down the road, please feel free to contact Brian or I. And Angela is going to bring us home here.
Okay. Hey, I had a question myself for hiring. So if you're hiring and you interview 5 people and 3 of them are in their 20s-ish, can't tell, 2 of them are in their 40s, how do you protect yourself if you want to hire one of the younger set?
Sure.
How does a age discrimination suit start with hiring? Like, how do I, if I'm not in the employee, if I'm not an employee, how would an applicant get the information to to create that suit?
So I've handled one of those actually, an age discrimination suit by an employee not hired. And the way they get the information is they will in order to file the EEOC or the PHRC complaint, they only need to believe, I believe I wasn't hired because I'm over 40 and they hired somebody younger than me. And you may have hired somebody younger than you, but if you follow some of the things we've put out, you have a great job description that establishes not only the requirements of the position, but the qualifications for someone to have it. If you're intentional about your interviewing process and make sure that your questions are good questions, that's a great way to avoid litigation down the road. Make sure that your hiring decision is based on the qualifications of the people that are in front of you. Some employers are going so far as to eliminate dates and information on resumes when they circulate them to the hiring managers, so that you don't know how long ago that person graduated school or what years they worked at various jobs. Employee counselors that are trying to help people find jobs will say to people, look, truncate your resume. Take this job that you had in your 20s off. It's not relevant to what you're looking for anyway. And then the number of jobs you have is less. But doing things like that are a good way to avoid it. So if the if the HR person receives the resume or the information, and they take all the dates off it, high school graduation date, college graduation, if it's applicable, what years they worked at various jobs, and all you have is the jobs they've had, it's harder to tell who's old, who's not. Yes, you're going to see their face at some point and and look at them, but at that point you can say, look, I don't know how old this person was compared to this one. They could be about the same age. Yeah, that person looked a little older, but this person had the skills that we required. Here's the job description. Here's the comparison of the skills, and that's why we hired this person over that one. There are a couple of tips on how to avoid that, but if that claim arises, knowing what your hiring process is and making sure it's established in a way that avoids the question is a good way to go about doing that. You can't avoid it every time. Somebody's going to raise the question. But if they can look back at your hiring process and say, well, we tried to protect ourselves from this claim by eliminating dates on resumes or not asking people what year they graduated high school and all of those things, you're insulating yourself from the accusation as best you can.
Thanks, Brian. If there's no other questions, we will go ahead and end the session. The recording will be made available, and Cindy will be distributing a handout for the registrants for this evening. I thank both of our speakers for your presentation this evening. I've gotten a couple emails that said that they thought it was a great presentation. So at this point, we will shut off the recording and wish you all a very good night.
Thank you.